since the summer. My name is Bill Herbert, and I'm the New York City Lera chapter president. Before we begin, I want to express our chapter's appreciation to the American Arbitration Association and the staff for the use of their offices today, and to Lera national staff, Emily Smith and Bernadette Kierman, for their tireless help on behalf of our chapter. We also must thank Epstein, Becker, and Green for being the CLE service provider for today's program. Lastly, I want to thank and acknowledge arbitrator Dennis Campagna, who helped to develop this program but is unable to participate today. If not already done so, we encourage you to renew your membership in our chapter or join us. The chapter leadership is dedicated to broadening our contacts and the subjects of programming. So please join us and become active in the chapter. Tonight's presentation is titled Legal and Agency Updates from the National Labor Relations Board, the Public Employment Relations Board, and the Office of Collective Bargaining. So we're going to be covering basically 4 different statutes, two private sector statutes and 2 public sector statutes. You should have already received an email containing the presentation materials, evaluation form, and CLE affirmation form. Please let us know if you did not receive this email so we can send the materials to you. We also have posted the materials on the Lera website. For those virtual attendees requiring CLE credit, please write down the attendance verification code, which I will be announcing during the program. So you can put it onto the affirmation form and then submit it to get CLE credit. Please complete and return the form as indicated at the bottom of the form after the end of the program. And as a courtesy, please mute yourself during the presentation. For those who are in attendance today in person, the CLE information is on the credenza to my right, and you should pick it up and fill it out once once the program is completed. So what we're going to do is we're going to start with with introductions that I'm going to present, and then we'll proceed in the following order based on the introductions I gave. Our first speaker tonight is John Doyle. John was appointed NLRB Region 2 Director in August of this year. He joined the agency in 1995 and became a field attorney the following year. During his tenure, he's a rising star, receiving a series of promotions over the years. Immediately preceding his current position, John was the NLRB's Deputy Associate General Counsel in the Division of Operations and Management. John will be discussing and addressing recent initiatives by General Counsel Jennifer Bruzzo concerning remedies and settlements, as well as other areas where the General Counsel has expressed interest in the board examining. We will be examining. To my right is Bill Conley. Bill is the Director of Office of Conciliation of the New York State Public Employment Relations Board. In addition to overseeing the impasse procedures under the Taylor Law and the State Employment Relations Act, Bill mediates impasses and conducts labor management training. Prior to joining PERB, he served as Upstate Regional Director for the New York State Nurses Association. Bill will be addressing PERB's impasse procedures, recent precedent relevant to those procedures, as well as an upcoming operational change at the agency. Mariam Manichaikul currently serves as Chief Mediator and Regional Director at New York State PERB in the Brooklyn Regional Office. Mariam has worked in labor and employment law throughout her career as a neutral at various agencies at the municipal, state, and federal level, as well as an advocate for unions as well as management. Mariam will be addressing various issues, including precedent under the Farm Labor's Fair Practices Act, the 2019 statute that expanded PERB's private sector jurisdiction to include collective bargaining rights of farm workers in New York. And our fourth speaker is going to be Stephen Starr. He's Deputy Chair and General Counsel of the New York City Office of Collective Bargaining. Prior to joining OCB, Steve was a partner at the law firm of Meyer Swazi, practicing labor and employment law. Steve will be providing us with an update on recent OCB decisions related to the COVID-19 pandemic, as well as other issues. Now, a long time ago, Franklin Roosevelt described December 7th as a day of infamy. But at New York City PERB, we consider December 7th to be Stephen Starr Day. Today is Stephen's birthday, and so we brought a cake for him, and we're very thankful that he took the evening of his birthday to come present for us. And we want to also extend our best wishes to everyone who in the past years had a birthday, which I assume is everyone, and we're very thankful for that. So with that, and I should also, one other point, we have 3 agencies dealing with 4 different statutes. And one thing that I think is important to recognize is that when we deal with, as practitioners and as neutrals, when we are dealing with these agencies to recognize how hard the staff are and how much the need is for all these agencies to receive increased funding as necessity. That's my own personal view, but I think it's really important to recognize that agencies are getting more responsibilities and they need more resources to be able to fulfill those responsibilities. So with that, I'm going to turn over the program to John Doyle, who's going to be using a PowerPoint for his presentation.
And started in the middle.
And you know, technology never fails. Technology never fails, right? So,
Be able to, maybe if you left, click it, we
Right.
can go back. again. Good evening, everyone. I'm really glad to be here to speak with you.
we have to go to the top of the PowerPoint. So let me just
Okay.
my escape. So can you just move that up? So, Yep.
It's here, not.
maybe
Go
maybe
get it.
maybe maybe just do one escape. Maybe just escape.
Help is on the way.
Share the screen now. So the share function.
No, I'm a first year. Yeah, I'm doing more. But you want me to have exposure to traditional labor stuff too. So it's great.
All right, everything's live. Figured out the technical problem. So again, I'm John Doyle. I'm the regional director in Region 2, which is Manhattan. I've been in my post for about 3 months. As Bill mentioned, I've worked for the agency in a number of different capacities over a number of years. And today, I'm going to be giving an update on some recent NLRB General Counsel remedial and substantive law initiatives. Our agency's general counsel is Jennifer Bruzzo. She took office on July 22nd. Actually, I've got the wrong year there. It's 2021. And since taking office, she has had a very ambitious agenda regarding remedies, both to secure from the board and the standards for regions to secure in settlement agreements. And she's identified a number of areas of substantive law that she wants to ask the board to re-examine. And her agenda in these areas is laid out in 3 general counsel memoranda, which issued in short succession after her taking office, which I believe were provided with the materials. And their memoranda, General Counsel 2104, General Counsel 2106, and General Counsel 2107. And so what I'll be doing is, rather than attempt to give an exhaustive presentation about this, is try to hit a few areas a bit more deeply that may be of interest, and talk with you about our experience in the region in administering these, as well as some updates on where the various initiatives are that are going for board consideration. in that process. So memorandum GC 2106 is entitled Seeking Full Remedies. It issued on September 8th, 2021. It emphasized the General Counsel's commitment to full remedies and described examples of previously awarded remedies that regions should routinely consider, as well as identifying remedial relief that boards should advocate the board to order that were not part of what was either A, traditional, or B, even precedented. So there are a few of these that have gone before the board. The board issued a notice and invitation to file briefs in Thrive Incorporated, which pertains to a framework for awarding consequential damages. So what happens when the board issues a notice and invitation to file briefs is it signals an interest in reexamination of a broad doctrine. And so rather than getting briefings only from the parties and the general counsel on that, they invite amicus briefs. And that case was November 10th, 2021. And in certain circumstances, the board has applied examination of what consequences flow from an unlawful act based on the egregiousness of that act and others as sort of a standard remedy. And so the board, and interestingly, all 5 members joined this notice and invitation to file briefs, because even though they may ultimately disagree on the outcome of it, they all believe that's an area of board law that requires reexamination. And so the briefs are in, but this is one of a number of cases which we'll identify here that are pending board consideration. And this is a PowerPoint that you'll be able to receive by email if you have not already. So you don't necessarily need to take notes on the sites as I put them up. Now, a second one where it's not been a notice and invitation to file briefs, but the general counsel's remedial approach has been briefed to the board in Longmont United Hospital. And there's a number of other cases where this is also briefed, but here I'm putting kind of the lead one that contains the general counsel's argument. And here the general counsel is urging the board to overrule Ex Cello Corp. in order to make whole remedy for the lost opportunity to bargain. So when employees elect union representation, they signal their interest in having collective bargaining, and the act entitles them to that. But sometimes it is delayed, either because there is a test of certification that goes to the federal courts, or it may be because the employer simply commits violations. And so the amount of time that that elapses between the union winning the election and the good faith bargaining actually occurring, the current remedial framework doesn't furnish a remedy for that. There's no unilateral changes, but what about the benefits from collective bargaining that employees may have obtained? And so in this brief and in others submitted to the board, the general counsel is asking the board to order a make whole remedy to be determined at the compliance stage and assess what either raises, improvements in working conditions, what monetary value predictably would have been available to the represented employees during the period of time that their choice for union representation was not honored. So we don't as yet have a decision from the board on this, but it has been briefed in a number of cases. Another remedial issue, and this one sort of straddles both a remedial and a substantive law issue, but in Cemex Construction Corp, the general counsel has urged the board to overrule Linden Lumber and return to the rule of Joyce Silk. And this arises in the context of the framework for Gissel bargaining orders. Currently, the remedy for unfair labor practices will be a bargaining order based on card majority only if there are very severe, pervasive, egregious unfair labor practices such that the prospect of holding a fair rerun election is either impossible or impracticable in all of the circumstances. Prior to Linden Lumber, under the rule of Joyce Silk, employers were expected to honor demand for recognition unless they had a good faith doubt as to the union's majority status and where they committed unfair labor practices that would be strong evidence that they did not possess a good faith doubt. And so a much lower level of violations than required for Gissel bargaining order would result in a bargaining order under Joy Silk. And so the way the general counsel has approached these cases is it's been, for example, on the Joy Silk matter, where the general counsel believes that there's a remedy, a need for that remedy, even under extant law. So there's a need for a Gissel bargaining order in the general counsel's view, but it's an opportunity for the board to revisit the standard in deciding. So either because the board doesn't agree with Gissel, or they agree that yes, this is sufficient under Gissel, but this is an opportunity to change the standard. And throughout the cases I'll be discussing, the general counsel's approach has been to issue complaint or advocate for a remedy only where there has been unlawful conduct by employers or by unions under extant law, and to use those vehicles as opposed to cases where there is no violation under extant law. In those sorts of cases, the general counsel has generally dismissed the cases entirely rather than proceeding. But where there are other violations or the remedy sought would be warranted in any event, the general counsel has used that as an opportunity to ask the board to revisit precedent. Turning to Memorandum GC 2107, which almost immediately followed the 2106, this is full remedies and settlement agreements. So rather than what relief are we going to get on the litigation side, this memorandum gives guidance to the regional offices on what is going to be acceptable short of litigation to resolve cases and settlement agreements. It's set 100% as the back pay and other economic losses as the expectation for settlements, removing the region's discretion to accept less without approval from headquarters. So previously, there has been an 80% rule that in the interest of avoiding litigation, conserving resources, if the parties were agreeable, regional directors could, without seeking headquarters approval, approve an informal settlement agreement at 80% of the back pay if the other remedies were there. But this general counsel's view is that we really need 100%. And while there may be circumstances that warrant a deviation from that, all of those need to be cleared with our headquarters division to ensure that there is a consistent approach. And generally, we have been getting 100%. It has been experienced in our region and most others, again, unless there's a particular reason that something different from that is warranted. And I don't have the numbers in front of me or in front of us, but the settlement rate has remained remarkably stable at upwards of the 90% mark. That memorandum also limited inclusion of non-admissions clauses. Basically, we're not admitting non-admission clauses to the settlement these days. There are a few circumstances where there might be a special exception, but as a general rule, this initiative has also just yielded results of settlements that don't have non-admission clauses. It also reinstituted default provisions as the standard for our settlements, and this pertains to if the charge party doesn't comply with the terms of the settlement, then in those instances, all that the general counsel need prove is that the settlement was not complied with, and all of the allegations of the underlying complaint are deemed to be admitted, and we can go forward for a court order and default judgment and court enforcement of the board's order. This had been instituted, I want to say around 2011, 2012 under Acting General Counsel Leif Solomon. It was continued and expanded under General Counsel Richard Griffin. It was rescinded as the agency's approach under General Counsel Peter Robb. And so Memorandum GC 2107 reinstated that as sort of the way of doing business. It also proposed this memorandum a number of new remedies to obtain in settlements rather than through litigation, including training for supervisors and/or employees, either so that supervisors would be less likely to commit violations inadvertently, and so that employees would have a greater awareness of their rights, letters of apology an employee sponsorship of work authorization application in instances where someone cannot be reinstated because they don't possess work authorization. The third memo that I'll touch on here is Memorandum GC 2104, mandatory submissions to advice. This memorandum identified 18 general areas of substantive board law, each with bullet points where the general counsel was interested in board reexamination of precedent. It's total of 51 bullet points across those 18 areas. And again, to both to conserve time and so that the presentation isn't a mile wide, but an inch deep, I'll just talk about a few areas where the board has either taken action or signaled an indication to do so, or at least the general counsel's position has been briefed and put before the board. So one of these so far has been decided, Valley Hospital Medical Center, pertaining to dues checkoff surviving contract expiration. This was a case that had gone to the circuit on a board decision that the dues checkoff did not survive. The circuit had expressed difficulty understanding the board's reasoning, remanded it, and on remand, the board, and there was a change of members, but the board reversed its precedent, and the current extant law is that dues checkoff must continue even after contract expiration pending bargaining. There have also been notices and invitation to file briefs in the Atlanta Opera Inc., which pertains to the independent contractor standard. Stericycle pertaining to the standard for lawfulness of work rules that was described in the Boeing Company. Notice and invitation to file briefs in Ralph's Grocery, which pertains to confidentiality agreements, confidentiality requirements and arbitration agreements. Now, these cases are ones where the GC's view has been briefed to the board. Now, in some of these cases, the board has decided the case without taking up that issue. So they're still included in this PowerPoint because you can see what the general counsel is arguing for in those briefs. And I think in all of the instances, there are other cases pending before the board where the board may take it up. But this relates to American Federation for Children, the construction of concerted activity and mutual aid and protection that the previous board expressed in Allstate. In Lion Elastomers, the general counsel is urged to return to Atlantic Steel pertaining to the standard of assessing whether a union representative has lost the protection of the act in connection with fulfilling their union representation duties by inappropriate conduct. The Atlantic Steel case had for many years left the standard that there was a kind of an ability to stand as equal with management and engage in intemperate behavior that might warrant discipline or discharge if it occurred on the shop floor, but was immune because it occurred in a grievance meeting or other advocacy setting. So the general counsel in Lion Elastomers is urging the board to return to that standard. In Tobin Center for the Performing Arts, the general counsel has urged the board to reassess the off-duty contractor employee access for union organizing activity and to return to the standard previously in New York. Strategic Technology is a case regarding particularized animus and reliance on pretext as narrowed by the previous board in Sigfree and Electrolux. And so again, it's not exhaustive, but I wanted to give you sort of an overview, and to the extent there are questions, I think our plan is to take those up at the conclusion.
Right, so if those who are attending virtually, if you have questions related to John's presentation, we'll put them in the chat now. We'll get to them after we finish with all the presentations. So John, thank you very much. That was great information about where the board is heading or where the general counsel is seeking to lead the board. Our next speaker is going to be Bill Conley, who's going to be discussing developments at New York State PERB.
It's good to be here with everyone. See some familiar faces and some new faces. So it's great to meet new people. First topic that I'm going to discuss is a procedural change that's going to take place on March 1st within the Office of Conciliation. This is long overdue, but we are going to adopt electronic filing, again, effective March 1st. So I do see some smiles. I wish we could have done this sooner, but again, that'll start March 1st. If you have any questions with that, you have a handout. You should have a handout, impasse procedures under the Taylor law. Pages 19 and 20 go through the process. The short of it is there are going to be there are two email addresses, and those are posted on our website. One is dealing with any impasse related documents. The other deals with any arbitration or disciplinary documents or matters before us. So that's how the two baskets are separated. And hopefully this is going to speed up our processing of cases, make it a little bit easier for you folks, and move us at least into the new millennium. Now, please note, this is for the Office of Conciliation only at this time. The rest of the agency is in the process of reviewing and undertaking what their needs will be to move in the same direction. The next topic. There's been an amendment to the Taylor law, and this goes back to 2000 and I believe it is 20, and that is the Upstate Transit Authority, 2021, I'm sorry. Upstate Transit Authority members are now eligible for arbitration under the Taylor law. Prior, only Metropolitan TA Authority members were eligible for impasse arbitration. So I know there are some folks in this room that participate in that sector, that are advocates in that sector. We have not had any cases coming out of Buffalo, Rochester, Syracuse, or Albany to date. But your handout, I believe on page 18, talks about those changes. So it probably be good for those of you that practice in the IA realm and the transit realm to update yourself. I am interested to see what is going to come out of the next round of bargaining. It's always interesting when you have an amendment of this sort because throughout interest arbitration, whether it's police and fire or downstate TA authority contracts, there are comparables, a lot of comparables. Once you move upstate, well, there really aren't comparables at this point in time. Yes, there are terms and conditions and there are contracts, but it's a different world because there are no impasse arbitration awards for these upstate entities. So I wanted you to be mindful of that. Next, I'm going to get to this is one of my favorite cases that PERB has come down with in recent years. And unfortunately, it hasn't gotten enough publicity, and that is the town of Blooming Grove and the Blooming Grove Police Benevolent Association. So I couldn't tell you how many scope charges have been filed at the agency over the issue of the duration of contract proposals that are on the bargaining table when the parties go to interest arbitration. Now, under PERB's rules, the rules always required the parties to submit their bargaining proposals before they go to interest arbitration. To me, it always seemed rather straightforward that if two parties are bargaining, the proposals that should be set forth at the time of interest arbitration and forwarded would be those proposals that are actually on the bargaining table, most recent bargaining proposals. Just always seemed to be common sense. Now, unfortunately, PERB ALJs had dissenting and differing opinions for 15 years. In 2018, the board came down with Blooming Grove and they settled this issue. The board went out of their way to give strong guidance to parties by stating, in the interest of providing future guidance to these and other parties, we note that the town's asserted reason for submitting 2-year demands initially because of the interest arbitrations panel lacked authority under the act to issue an award exceeding 2 years, because except in certain instances, IA awards are limited to 2 years. Certain state contracts, et cetera, can be 4 years. So parties would say, well, you can't put a 4-year proposal on the table because the IA panel can only make a 2-year award. So the board went on to say, that it simply put, we find that it is not unlawful for a party to submit demands to interest arbitration that exceed 2 years. Whereas here, the parties have been consistently negotiating for a contract that exceeded 2 years. So this is a case that I want everyone to be aware of. So people realize that when they're bargaining, if you can bargain a 6-year contract, then all the more power to you. That's what we want to encourage. We want the parties to bargain contracts that work for themselves. When it comes time, if there's a need to file for interest arbitration, you're just simply to submit your most recent proposals as part of your interest arbitration petition or answer. All right, so I just wanted to make sure people are aware of that. That is, again, that had been a pet peeve of mine and my predecessors for many years. And I want to make sure everyone was aware of that. Now, I'm going to hand this off to Mariam, and she's going to talk about some cases, recent cases at the agency. She's going to talk to you about the Farm Workers Labor Practices Act, and then circle back where I'm going to also talk to you about farm workers. Thank you.
Thank you, Bill. Again, if anyone has questions, please add them to the chat function. I know someone put in requested that we increase the volume, so we're working on that. But for now, I just want to make sure for those who are attending virtually and want to get CLE credit, let me give you the attendance verification code right now. Okay, so get a pen, piece of paper. The verification code that you need to put on your affirmation when you're submitting for a virtual attendance is the following: EBG 127. That's EBG 127. If anyone has played bingo, you know what that's like. But anyway, just be in the form EBG 127. You want to proceed, Mariam?
Sure. So I'm Mariam Manichaikul. And as Bill also mentioned before, it's great to see so many familiar faces and meet some new people. And before I get into some of the more substantive matters, I thought I would give you all especially those who aren't familiar with me and my office, some background about what I do in Brooklyn. So as Bill Herbert mentioned, at PERB, we are now responsible for administering the Taylor Law, as well as which covers public sector employees, as well as the State Employee Relations Act, which covers the private sector, certain employees. It's fairly wide sweeping, but private sector employees. And so in order to do that, the Brooklyn office has a staff of administrative law judges and mediators who play roles in adjudicating and mediating disputes, both improper practice disputes, which go through a hearing process, as well as bargaining impasses, which are processed through Bill's department, the Department of Conciliation. So the various offices with which we work are the Conciliation Department, as well as the Office of Public Employment Practices and Representation, and the Office of Private Employment Practices and Representation. And in terms of, I would say, a more practical development that we've undergone recently, which I think is probably fairly common and widespread in our world now, or the world at large, is the use of online technology, or I guess technology, online hearing processes and mediation processes. As we're doing right here during this this presentation, we're able to have people from wherever they are join us. And so that started right after our closure of our physical offices in, I guess, March of 2020. It took a little bit of time to get off the ground and running with that, but I think by June of 2020, we were using Zoom technology to hold hearings and mediations and conferences and process just as we always had was the idea. And I think there was some apprehension at first as to how this would work. I will just say from my personal experience, I found it incredibly useful and a very seamless transition. I think that's fairly widely held belief, but I think the parties also largely, I think people have enjoyed being able to use these processes. Just from a practical standpoint, I appreciate being able to see all the speaker or all the participants right there in front of me at the same time, see everyone's face, and also spotlight whoever is testifying. I like the ability to use the breakout rooms to give people some privacy for caucus, to change around the rooms very seamlessly and easily between caucusing with parties versus bringing advocates together. I found it really great. There's also the ability to share documents across the screen, which I didn't realize how helpful it would be to be able to control what people are viewing during the course of a hearing or a mediation. Make sure that the entire virtual room is literally on the same page, right? We are all looking at the same language, the same document. There's no confusion as to what is being reviewed at any given point. We also have, and I think Bill uses this, the screen share ability and remote control. So we've been able to use that to quite literally work together. To work together to draft language, even though we're all in, could be, tens or hundreds of miles apart in some cases. We can all use Zoom at the same time to edit a proposal together or a draft contract. And I found that that sometimes doesn't even happen in when you're sitting in a physical room with people, to have people literally working on the same document. So I found it actually really exciting. I think that it sort of adds a spirit of collaboration into the process. So anyway, for what that's worth, I think there might be different opinions on the virtual technology versus in person. And I think there are times when it's undeniable that in-person is called for various reasons. And that is something that is still available through our agency. It just needs to be voiced in the representation side. I think in conciliation, there's perhaps a more active movement towards in-person if that's desired. But anyway, I just wanted to give my 2 cents on that. I did want to bring people's attention to a couple cases, recent cases that have been issued in various arenas. One case is a recent decision issued by the Court of Appeals, and another is an ALJ decision that I found notable, as well as one recently issued by the board. So it gives you a sort of broad spectrum of cases. So the first one is a recent case issued by the Court of Appeals in City of Long Beach, which was brought originally by the Long Beach Professional Firefighters Association. And in that case, there was a question concerning the negotiability of procedures arising relating to Civil Service Law Section 71, which gives employees who are separated from service due to a disability from an occupational injury or illness, the ability to be on leave of absence for 1 year. And then the question is what then happens upon termination of employment. So there was a question of whether procedures for such terminations were required to be bargained, and the Court of Appeals affirmed that they were required. And I think if you read the decision, something that really stood out to me is the multiple times that the Court of Appeals explicitly called out the City of Watertown decision and the emphasis on the agency or the statewide sweeping policy. It's referred to favoring bargaining. So I think that sort of goes to the heart of who we are. So it was nice to see that affirmance repeatedly and explicitly. Geez. Can people hear me in this room?
It's a question
Yeah.
on Zoom, they're not being able to hear you.
Oh, they can't hear me.
So if you could talk louder, it would also affect the camera. The camera will be able to see you if you
Okay.
speak louder.
Okay.
Also, you should tell those who are attending virtually to turn up their volume,
Right.
because the
Those,
IT says that it could be
Right.
on their end.
but I think it's the microphone here. So if you could just raise your voice a little, I'm getting messaging various ways about that.
Okay, I will try to speak up.
Thank you.
So another case I wanted to draw people's attention to is the County of Tompkins and the county sheriff, which was a charge brought by the Tompkins County Correction Officers Association. And why this is, I think, interesting is I believe it's the only decision thus far issued by our agency concerning COVID vaccination and testing, and whether it is required to be bargained. And in this case, an ALJ, Brittany Sargent, she decided that, you can read her decision, but she found that implementing this requirement of COVID vaccinations and testing was for certain a work rule under our jurisprudence, but that she weighed, which our law requires a balancing of interests. She weighed the employer's core mission, which she defined as protecting the health and safety of employees and the public during this COVID international pandemic and public health emergency, versus the employee's interests, which were explained as discipline for non-compliance and various duties to test and so forth. And she found that the employee's interest did not outweigh this core mission. She did highlight that these were essential employees that were required to deal with the public. And so she did make that note, but I wanted to draw attention to that and note that I believe it's not been appealed. So it's so there's that. And then there's one more case that I'll discuss in the realm of the Farm Laborers Fair Labor Protection Act, which, as Bill mentioned, was signed into law in 2019, became effective in January of 2020. It amended the State Employment Relations Act, which is our oldest statute from the 1930s, actually, which grants collective bargaining rights to all employees in New York State, except where specifically excluded. So very broad, but for a long time, farm workers were specifically excluded from rights. And actually right before the passage of this law, the courts had found that it was a violation of the Constitution to exclude these workers from rights anyway. So in any case, this amendment came, and now PERB has jurisdiction over these farm worker protections for collective bargaining. Just to bring your attention to a couple points of interest, it mirrors in some ways the Taylor law in there's no striking permitted, and there's a maintenance of the status quo required, which means continuation of the terms of an expired contract. It also is, I believe, a ULP to lock out employees. And it's also notable, I think there's language aware that an employer may not guide or discourage membership, which is a difference we can talk about later if people have questions. But so just to give some background about how we've processed this, the law became effective in 2020. We dealt with the winter, which is, that was January. It was winter time. I don't think it's a high organizing time for farm workers. And then we had COVID. So at the outset, there have been very few units that have been certified. The ones we've seen have generally been smaller units on Long Island and Brooklyn, vineyards, wineries, nurseries, and small farms. But in the last few months, we've seen several petitions filed for larger units in Poughkeepsie and Rochester, larger farms up there. So just to quickly draw your attention to a recent board decision on one of these certifications, it is Satter Farms, which was issued by the board in October of this year, affirming an ALJ's decision to certify a unit without an election. And dismissing the employer's objections to that decision. And so just in a nutshell, it seems like I'm talking a bit long here, but the employer had alleged that dues authorizations cards were obtained by fraud. And the fraud that was alleged was that prepaid debit cards of an undisclosed value were promised and then not delivered to employees in the field. And the board found that the ALJ did not err in not holding a hearing on those allegations, that they did not raise an issue of material law or fact. And they found certain problems with the affidavits that were presented by the employees in support of the employer's case, or along with the employer's case. It's also noted that the employer raised that their employees had wanted to revoke their authorization after the fact. They changed their mind and they no longer wanted to authorize dues. And the board found that that was not a sufficient basis to invalidate a card that was otherwise clear on its face at the time of signing. So I will turn it back to Bill for, if we have just a moment, to talk about the impasse procedures and mediation in the farm workers venue. If we do have time for that.
I'll make this short.
Okay.
So Mariam mentioned there's been an uptick now in petitions that we've received. And we have certain certifications working their way through the process. I wanted to bring your attention under Sarah to a couple of points for those of you that might be doing work in this area. First of all, under Sarah, the farm workers have card check. So that is a huge change. A lot of the disputes that we're seeing are fleshing out when elections might be available, because the default is a card check and it's a very high standard for there to be an election. There has to be, I believe it's convincing evidence of fraud or coercion, which again is a high standard. We are starting to see, there's a provision under Sarah called the Special Mediator, Section 702. It is extremely broad, where we're able to send an individual out into the field with full powers of the board, much greater power than a mediator under the Taylor law. I was assigned special mediator in one case so far. You're going to want to read the statute and look at what we can offer you as far as mediation. Definition of labor dispute under Sarah is extremely broad, very broad. Again, our Office of Conciliation is there to offer the parties whatever assistance we can bring to you. We are going to the farms in the fields. That's where we will be. It really is a brand new frontier for collective bargaining in New York State. So it's exciting. We have our work cut out for us, as we are all, as a labor relations community, we are working to build this from the ground up. It does not currently exist. From a bargaining perspective, you should be aware there are very tight timelines for declaring impasse, for moving from mediation to, yes, interest arbitration. We call it impasse arbitration under Sarah. farm workers have impasse arbitration. Again, it's a tripartite panel as with the Taylor law, but we as practitioners and neutrals are going to have to develop the bargaining culture that has taken, 50 plus years under the Taylor law. We are going to have to build that under Sarah with regards to the farm workers. So I just want to make sure we're all aware of that. We are going to have to make this work, and whatever we can do to help. My email address is on the presentation you received. Any questions you have, because obviously time is short, please send me an email. Phone number is 518-457-2690, 518-457-2690. For new practitioners or experienced practitioners, if you have questions, we want to answer your questions and be of help. So please pick up the phone and give me a call. Thank you.
Thank you, Bill. Thank you, Mariam. So just a reminder that if you have questions for the speakers, you can use the chat function for those who are attending virtually. If you haven't noticed, we've now covered 3 statutes, one a federal statute involving labor relations, collective bargaining, and then 2 state statutes, one dealing with the public sector and one dealing with the private sector. For those who are interested in following the issues involving the State Employment Relations Act and the farm worker bill, there's a lot of action going on in that area, and the statute is, as Bill mentioned, very broad. So our 4th speaker is our birthday boy, which is Stephen Starr, and we're very pleased to have him to talk about the Office of Collective Bargaining, which again is an agency which has both deals with representation issues as well as impasse issues involving collective bargaining. So Stephen.
Good evening, everyone. Bill stole my first joke, and so I'm just going to go right past the birthday thing. And it's nice to see everyone, get to see some familiar faces. Like he said, my name is Stephen Starr. I'm the General Counsel at the Office of Collective Bargaining. And so what I'm going to talk about mainly are some of the cases that have come out this year that have to do with the city's vaccination mandate. It's probably the most interesting stuff that's come out, and so I will I'll get right into it. So the first case that I'll mention is the one brought by the Municipal Labor Committee and a series of a dozen or more other unions that joined the litigation, and with respect to the city's vaccine mandate, it's the first one that was decided. I think the first one that came in. They sought an injunction, which they did not get, and then the case, was processed. The central part of the case, though, was they did not challenge the mandate itself. They were challenging primarily 2 things. One was that the city didn't bargain the procedures for implementing the mandate, and that the mandate was announced, I believe it was on October 20th, and then implemented on October 29th. And so the union, so the MLC and the other unions had an issue and felt that that was an insufficient time for the city to realistically bargain over the impact of the mandate, and so ultimately the request was just a finding that that the city was required to bargain over the implementation, but they did not seek any kind of retroactive remedy. And so the board did find that the city was obligated to bargain over implementation, particularly like use of leave and other, it didn't set out a series of things that they should have bargained. By the time all the papers were filed and the board was considering the parties' positions, the vast majority of the city and the various unions had settled their issues. And so there were only a handful of unions left at that point, primarily in the uniform titles that had not agreed to settlements. And so the board ordered bargaining on any remaining issues, and and so far we've not. There was no appeal, but we're not aware of what additional bargaining has gone on. I'm not saying it hasn't. We're not a part of it. And so there's another case that was filed by the UFA, the firefighters, and but they had also joined in the MLC case. There are, and so a lot of the issues that were in the UFA case are similar to the ones that were decided in the MLC case, but that case is still pending because they challenged the mandate directly, and that was not decided in the MLC case, and as a complication, after everything had been submitted and the board was considering the parties' positions, there were two Supreme Court cases, New York Supreme Court cases, that came down in October and November. Up until that point, litigation to challenge the city's authority to issue the mandate had at times been briefly, parties would get a TRO for some brief period of time, but then ultimately the courts have come down and said that the city could issue the mandate for those who said that challenged whether or not people were entitled to disciplinary due process. The court found that it was a qualification and therefore disciplinary rights did not attach. But in September 23rd, this year, I'll give you the index number. It's 151-531-22. Justice Frank, New York County, issued a decision that found just the opposite. That was not persuaded that this was a qualification, and distinguished other cases that were referred to, that compared it to a residency requirement, and found that the Department of Health did not have the authority to impose like employment, to bar people from their employment, that under certain provisions for the Department of Health or the powers of the commissioner, that they were only limited to issue monetary penalties. And so there was no basis for them to issue something that would bar people from the workplace, which then led to the mayor's ordering the mandate or putting people on leave. And so that case is appealed, as is a case that came out out of Richmond County, Staten Island, that affected sanitation workers, that was issued by Judge Porzo. The index number is 85163, 2022, on October 24th, 22, and essentially said the same thing. And in both cases, They reinstated people who were terminated because they did not get vaccinated. And in both cases, the city has appealed those decisions. And as of right, the orders are stayed until the appellate division hears the case. And so as of now, nothing has changed. But obviously, this coming up right as the same time as the board was considering whether or not the mandate was or was not permitted without collective bargaining. The parties have weighed in, and that's something that the board is still considering. And so on the one hand, the most recent decisions came out of two Supreme Court decisions and would weigh in favor of they needed to bargain. But on the other hand, there is a wealth of other cases that go the other way. And so that's an issue to be decided. There are two other cases that came up about the mandate, but both of them involved requests for arbitration as opposed to unfair labor practice charges for a failure to bargain. The first involved mostly trades titles, the electricians and the carpenters, but also there were non-trades titles that were covered by other contracts that were within the case. The trades titles had 220 determinations, meaning comptroller determinations as to what their terms and conditions of employment were. And then the other employees were covered by contracts. The basic notion of the case was there was an incentive given by the city that if unvaccinated employees got vaccinated during a brief window, maybe 10 days, then they would get a $500 incentive payment. And so the unions filed a request for arbitration claiming that the city should not have just unilaterally given this $500 incentive payment to a very sort of small group of people that fell within a very narrow window because the contract covers compensation and it covers different differentials and that there should be uniformity in what is paid, and they felt that an arbitrator should decide whether or not the contract would give, whether or not it was a violation of the contract to provide this specific compensation to just a small group of people. The board ultimately found that they didn't provide a nexus between the contract or the consent determination to entitle them to arbitrate that claim. That decision is on appeal, and so it's in the very early stages, and so there's nothing to report on that. And then the other was another UF firefighter case where again about about employees being placed on a leave of absence. They advanced a few claims. One is that that the contract provides for compensation and other uniform allowances and other things, and by unilaterally placing people on layoff and not giving them that compensation, they violated the contract. There were also they claim that putting people out on an unpaid leave of absence without allowing them to use their accruals and things like that violated their leave provisions, and that they have provisions about working outside employment, and the conditions under which you have outside employment. There were certain restrictions. If I'm remembering correctly, if you were out on unpaid leave, you couldn't work outside employment. And obviously that didn't anticipate people being put on unpaid leave involuntarily. And so the union argues, and so the board found that they did have a right to arbitrate the leave provisions and the provisions about outside employment, but there was no basis under the contract for them to arbitrate whether or not they should be compensated for times that they are placed on leave without pay. And
Steve,
yeah, I guess that's my time. So the
We
rest,
can get back to the questions from the audience. We can
yes.
come back to
And
anything
so
like-
I'm sure you're dying to know what I was going to say next, but I could just imagine it.
Leave them wanting more.
Yes,
So,
exactly.
I remind everyone, if you have questions from the audience, who are out in the virtual world, if you want to submit it through the chat function, you can. Before we move to questions, I want to just remind you of the attendance verification code, which is EBG 127, EBG 127 for those who are seeking CLE and are attending virtually. So let me start with one question that came from the audience and one question that I have for John. With respect to the remedies issue, the change perspective with regard to remedies under the General Counsel's memo, what has been the operational impact of that for Region 2? Is there been any examples where there have been pushback for trying to settle cases with these new remedies? Is there any experience on that? And secondly, there is a question from the audience about the question of the way in which the constant back and forth with NLRB precedent, and how can practitioners advise their clients? How can professors teach the law when the law is changing back and forth? And then this is the third question, which I don't think you have the answer to, is why is it that public sector precedent that's for 50 years has remained basically stable, while the NLRB, which and the public sector is of course more tied with politics, why is that more stable than NLRB precedent, which is private sector, although they're government officials? So the third one, I think you may not have the answer to, but the first two, I think.
So in terms of, and I guess I'll parse remedies that we're seeking through litigation, there have been a number of instances where, our cases involve failure to bargain, for example. And so some of the cases where the board has been briefed on make whole remedy are Region 2 cases, but those are cases that would have been litigated anyway. They weren't litigated over that issue. In terms of settlements, there's certainly been pushback. I guess it takes two forms. One is, practitioners for many years would advocate for, and other realms that may get non-admission clauses. They may not want to have default language. If someone stumbles and now you're being faced with the ability, they may have a claim that is litigable, and further the 100%. There's people like to have a discount. We're giving something, we want to get something. So that's definitely been something that we hear from practitioners. But overall, the bottom line is that, by and large, if there's a basis for an exception, maybe there's something in an overall deal that is going to heal a bargaining relationship, and that may be worth some compromise somewhere else, we'll seek and have obtained permission to veer from the 100% standard. But by and large, what we have found is that, it's just that this is what we have to have in settlements. We get roughly the same settlements, just with those additional terms in them. And the settlement rate didn't go up when the standards were relaxed. It hasn't gone down when they've been tightened. All that has changed to our experience, it has been what remedy we are getting in the settlements for them. In terms of the back and forth, GC 2104 identifies 18 general areas, 51 bullet points. There are a few other memos that address, a particular point of law, and that is, in aggregate, a significant number. But the overwhelming majority of cases that we see don't involve any of those, or it may be a sidelight that, okay, mostly we have standard ordinary bargaining violations here, but there's also failure to bargain over discretionary discipline, which is one of the areas that is disputed. So, I think that there are safe harbors. The General Counsel memorandum identifies these are the issues. It's not completely exhaustive. There might be one or two here or there, but if you know that these are the standards, there's a safe harbor, and your clients have the choice. Do we want to do something that we know this General Counsel will not challenge, because it hasn't been identified as something that is in that area, or do we want to advise in a way that, look, under extant law, this would be fine, but it's a disputed issue. The General Counsel has been clear and vocal, and furthermore, she has not prosecuted cases where there are not violations under extant law. That is something she has not done if there aren't violations by the charge party that we believe exists under extant law. So I think that it's a choice that clients will have to make as to whether they're going to stay within an identified safe harbor, or take the chance that they will either have committed other violations and be called to task for these that are ones where the board has vacillated, or there's interest in reexamination. In terms of teaching labor law, it probably makes it a bit more interesting than some other cases. Many of these are issues that are bread and butter issues, and affect what's use is the union if it's going to be years before we can get to the table. What if the objective was to get to some sort of an area standard, or something that others in a trade are earning, rather than going to work for one of those employers? Is there some time to that? So I guess there's a trade-off between stability and what will give us things to talk about at meetings like this, and get me more time than some of my colleagues. But I think that this is how it is. It's an interesting area, and in law school that was the professor would describe, look, there's been adjustments and adjustments back. And I think that the board members throughout all of my career with the agency have been people who believed in the act, who believed that it should be applied in a certain way, and the overwhelming majority of cases are ones that everyone can agree on what the standard is. This, even though it's a significant number of issues, doesn't intrude in most cases, and most dealings that your clients will have don't end up even being cases at all. So I think the slice of labor law that it is that is in dispute is it's significant, but I think there are ways to stay away from it. On the third, where I think you're asking for a bit of speculation, while there is politicization of public sector employees, there's not a real incentive for the government to have a lobby in it. And I don't know that ultimately it's being passed on to the taxpayers and to all of us. So the cost of employment of public employees. So I don't know that you have the same sort of strong interest from the management side that there would be, that's just an observation, and I'm not saying that that's the cause.
We're gonna ask the
Okay.
representative Herbert whether they agree that there's not pushback from employers to the public sector, but I appreciate that. So let me just move now to our the two speakers from PERB, and I wanted, you address that issue, whether or not there tends to be a perception that in the public sector that is somehow the employers sort of, and then also for OCB, for Stephen, whether there's a perception that in the public sector that employers don't fight back like in the private sector. And just in terms of your experiences on that, I'd be curious to talk about that difference now, particularly with the expanded jurisdiction of PERB under the State Employment Relations Act. The second issue I want to raise is the following. One of the things that the NLRB's General Counsel has done in one of her memos is talk about remedies involving undocumented workers. And it's likely that the population with regard to the farm laborers who are covered by CIRA, many of them may be undocumented. I'm wondering whether the PERB has taken any action so far in dealing with the question of remedies involving future cases which involve undocumented farm laborers.
I'll take the first question. So before I came to PERB, I spent 20 years as an advocate, both private sector and public sector. The manner in which employers fight back in private versus public sector tend to be different. I chalk that up to a couple of reasons. One, there's no strike in New York State under Taylor law. That's of course big. The employers cannot make unilateral changes to the terms and conditions of employment. But beyond that, there's a very small group of practitioners that practice public sector labor law within New York State. It's a fairly tight community, people that have spent decades in the field and are really generally able to work well together. And I think the majority of which still see a long-term relationship as valuable. Now, there are exceptions to that general rule. There are certain municipalities you might mention where, I might start to twitch, where you feel like you're in a private sector battle with everything but the ability to strike or impose. PERB is very fortunate. We are an executive branch agency, but we are truly recognized as a neutral agency. And we've had the good fortune going back to when we had Chairman Lefkowitz and his predecessors, that the governor's office, with few exceptions, does not apply any pressure on PERB. PERB is left to determine cases as they see fit. Bill, of course, was a general counsel for many years, and the professional staff has always gone out of its way to really determine cases on the merits. As far as the conciliation staff, we often, we deal with the state as an employer. We do not receive any pressure from the state. So we're very fortunate. And that was a question I had before I came to PERB. And again, I've been pleasantly impressed with the neutral status of the agency.
So before we get to, I want to ask you talk a little bit about the undocumented farm laborers. But before we get there, Stephen, do you want to talk about, you used to be in private practice, handled private sector cases, and now you're the general counsel for a public sector agency. What's your perception about whether or not there's the kind of nature of the relationship in terms of the way the cases are handled?
I mean, in the private sector, it really tended to vary a lot. Employer to employer, opposing counsel to opposing counsel. Sometimes maybe it was more the opposing counsel that it was the employer, but you never know. And we, we get pushback from both sides. It's not that the city is particularly less aggressive than I've seen in the private sector, except maybe for like certification cases. I think that most of the certification cases are not, there's a lot of, voluntary recognitions. Our law is much broader in terms of who is covered by collective bargaining. I think a lot of, I venture to guess, a lot of people who might be considered supervisors by the NLRB are covered by, by the New York City collective bargaining law. I think in terms of the stability of the statute, there's a significant difference in structure between OCB's board and the NLRB. OCB is a tripartite board, and so the mayor's office, the mayor through the mayor's office of labor relations appoints two board members, the municipal labor committee, who represents the public sector unions as a body, as a coalition body. They get to appoint two members, and then those board members vote on the impartial members. And so having, I think, representation by all three, both sides, and then neutrals, probably hones in the decision making more so than when you can make appointments that are one side or the other without the neutrals. And so
I just want to move to the private, back to the private sector with Mariam. With you, as I mentioned, the general counsel at the NLRB has laid out a memo about remedies dealing specifically with undocumented workers. I'm wondering how much is PERB ready for dealing with issues like that as these new cases are filed and are proceeding in the agency under the Farm Labor Fair Practices Act.
I don't know if it's something that the agency has explicitly received questions on or ruled on, and I don't know if there's any sort of declaratory or informative memorandum as we have been put out by the NLRB. I think the NLRB has case law on these questions some time ago about remedies for undocumented and coverage. Yeah, but in terms of coverage, I mean, I think that the act itself and the coverage of definition of employee is quite broad. And so I don't think there would be an exclusion if that's what you're saying. But with regards to remedies, I mean, the question I think might also come to the seasonality of this is perhaps an issue that might be addressed. And I think actually in this recent case I discussed Satter Farms, that was something that came up. They are very clearly covered regardless of consistency of their employment. So in terms of coverage, but
Have there been, are there
do you
pending?
mean remedies for ULP?
Yes.
I don't know that that's something the board has addressed or the agency has addressed. I don't know.
Are there pending ULPs involving the farm workers at this point?
I think there have been some. I don't know the status of those personally, but I think some of them have been withdrawn. Some of them have been filed and counter filed, and they were part of Satter Farms. I'm not sure, but I think the allegation was fraud. So, yeah. As to undocumented have been addressed.
So any questions from the audience in terms of, we've covered now again, three agencies, 4 statutes, lots to talk about. Any questions from the audience today? Silence, okay. So we are at 7:30. And so why don't we just go around the panel and just final comments from each of you.
Hey, everybody, it's my birthday. No,
What you're missing is that we have a birthday cake for Stephen. So we're gonna eat the cake and he's gonna bring it home. But that's after we turn off the school.
No, I don't really have any final comments. I mean, I think, it's just been an interesting year and, and so I just wish everyone happy holidays.
Well, it's great to be here. Thank you for the warm welcome. I've really been thrilled to work with the amazing staff in Region 2, and we've also had collaboration with our colleagues in Region 22 Newark, Region 29 Brooklyn to try to cover what we can. As some of you may know, the agency has experienced a significant uptick in cases. That's been particularly true in Region 2. Representation cases in particular were up 50% from fiscal 21 to fiscal 22, whereas our staffing has been down significantly. So those of you who practice before the region, I promise you that our agents are doing their best. We are prioritizing representation cases and litigation. We have to a certain extent, almost reaching triage mode on unfair labor practice cases and are sometimes treading water. But if you do have either a concern, an issue, a suggestion, please be communicative. It's important for me to be accessible to the practitioners, to the parties, to the community. My management team, Regional Attorney Olga Torres, Assistant to the Regional Director Kristen Ritter, take the same approach. So we've had some meet and greets with either trying to get out to various events or meeting with practitioners to just talk about experiences and what what the region can do or suggestions that people have. So we're certainly open to that, and I look forward to working with all of you.
Thank you for having us here today. I appreciate it very much. I just want to again mention that if you have any questions whatsoever regarding the impasse procedures under the Taylor Law, the State Employment Relations Act, please just pick up the phone or email. If you're senior partners, feel free to, conference in some of your younger attorneys. Really, in conciliation, we want people to feel comfortable picking up the phone. It's all about working with each other, trying to avoid litigation. So that's one thing we do not deal with in conciliation. So again, thank you very much and look forward to working with all of you.
Yeah, just quickly, likewise, as these guys have said, please feel free to reach out at any time. We really try to be available to general questions. Obviously, I can't comment on specific cases, but if you have like procedural or administrative type issues about how the agency functions and how to navigate our world, please feel free to reach out. I think you all who know me know.
Don't call. Never call. Quite the opposite. If you ever need anything, you can always
Call
reach out.
PERB, right?
Yeah.
So before we break though for the evening, I want to turn it over to Ayanna Blake, our Vice President, our Chapter Vice President, for some concluding comments.
So many of you are new. We haven't seen you before. I am the Vice President. Bill's the President. Our Secretary, Sudi, is not here tonight. We put a lot of thought into our programs, and we try to bring to you guys things that you will learn from, take from, and that are insightful and relevant. And we advertise our programs. And if you could, join Lera if you're interested in today's program. I don't know if you got this invite via an email or not, but if you are interested, leave your email, leave your contact information, because we like to see new faces and we have some exciting programs for the new year. So thank you for coming.
And if you have any ideas for programs that you would like us to present or you're interested in presenting, you have our email and you can just send us an email. We'd be very responsive to your suggestions. So with that, everyone have a good night. Thank you for joining us. And now we're going to be having food and beverages here. So next time you all should come to our in-person meetings, and we hope to be expanding them for the new year, and have a good holiday season and a happy new year. Thank you so much. Have a good night.